Personally, I think I might have an unpopular opinion here. I don't understand why athletics is tied to education. They don't seem to be related to me. They seem to be services that one organization can provide, but they don't seem to be related to each other. I get that historically athletics is a good idea, and colleges host athletics because they make money for the college, and then the college can focus on education. That sounds like you're doing a for-profit thing to pay for a non-profit thing. Moving on to a different kind of discrimination. So I've thought about whether I can get away with a clickbaity title here, and I'm going to be fair, and I'm going to try to be honest and candid with you. Instead of making a super clickbaity title, I'm only going to make a mildly clickbaity title. We've had this issue in national college athletics where the athletes are not allowed to be paid. And a lot of people, a lot of people are upset about this and would like to see this changed. These athletes are having their talents used to forward the colleges and other organizations surrounding them, and the athletes themselves don't benefit at a proportional rate. In other words, the athletes are bringing in millions of dollars, maybe even billions of dollars, for national college athletics, but the athletes are not allowed to be paid any portion or any significant portion of that money. Instead, they receive all of their benefits, pay, through non-cash education benefits. So instead of getting cash, they get an education. And in the past, the NCAA has put caps or ceilings or maximums on the education benefits as well as the cash benefits. And a court has recently held that one of those caps is illegal. Unfortunately, it's not the one that we want. The judge has decided in National Collegiate Athletic Association grant in aid cap antitrust litigation. A judge from the Northern District of California has recently found that the caps on education-related benefits are in violation of federal antitrust law, meaning illegal, meaning the athletes can be offered unlimited education benefits, and that's between them and their school and their program and their contract and all that. But the NCAA can't put limits, and the limits with cash income or getting paid for their contribution in college athletics, that cap is still allowed to continue unmodified. Plaintiffs are current and former student athletes who played men's Division I football and men's and women's Division I basketball. Defendants are the National Collegiate Athletic Association and 11 of its conferences that participate in football and basketball. Plaintiffs challenge the current interconnected set of rules that limit the compensation they may receive in exchange for their athletic services. Plaintiffs contend that these limits on compensation, which are set and enforced by agreement of defendants, NCAA, violate federal antitrust law because plaintiffs would receive greater compensation in exchange for their athletic services in the absence of these artificial limits. Defendants respond that the limits are pro-competitive for two reasons. First, the limits help preserve the demand for college sports because consumers value amateurism as defendants define it. Second, the rules promote integration of student athletes into their academic communities, which in turn improves the college education they receive in exchange for their services. The court resolves certain of the issues relevant to plaintiffs' claims on summary judgment and presided over a non-jury trial or bench trial on the remaining issues. The court finds and concludes that defendants agreed to and did restrain trade in the relevant market affecting interstate commerce, so that means federal has jurisdiction, and that the challenged limits on student-athlete compensation produce significant anti-competitive effects. The court further finds that the only pro-competitive effect that defendants established, namely preventing unlimited cash payments, unrelated to education, similar to those observed in professional sports, can be achieved through less restrictive means. Specifically, the court finds that an alternative compensation scheme that would allow limits on the grant-in-aid scholarships at not less than the cost of attendance, and limits on compensation and benefits unrelated to education, but that would generally prohibit the NCAA from limiting education-related benefits, would be virtually as effective as the challenged rules in achieving the only pro-competitive effect that defendants have shown here. The only education-related compensation that the NCAA could limit under this alternative would be academic or graduation awards or incentives provided in cash or in cash equivalents. The limit imposed by the NCAA could not be less than its current or future caps on athletic participation awards. Based on the findings of fact and conclusions of law set forth below, the court will enter a separate permanent injunction barring the restraints that the court finds to be overly and unnecessarily restrictive. Now, this is 104 pages long. There is no way I can cover all of this. So we're going to skip all the way to the end and see what the court orders at the end here. So here's a page 100. I think we might be a little bit early. So here's section 9 on page 101. We skipped a lot of material. So seriously, if you want to know why, you're going to have to parse through 100 pages or wait for us to eventually get around to it, maybe. No promises. For the reasons set forth below, the court finds and concludes that the challenged rules in their current form unreasonably restrain trade in violation of Section 1 of the Sherman Antitrust Act. The challenged rules constitute horizontal price-fixing agreements enacted and enforced with monopsony power. Wow, what is a monopsony?
A monopsony is when you have... Okay, so a monopoly is when there's like one company that controls services, and a monopsony is when there are a bunch of people offering services but only one buyer, or a very like small buyer.
A market situation in which there is only one buyer. Got it. Honestly, never heard that word before. That's a new one to me. This essentially eliminates price competition as to one key aspect of the recruitment of student athletes in Division I basketball and football, namely the labor that goes into these sports. As such, the challenged rules harm student athletes by depriving them of compensation they otherwise would receive for their athletic services. Defendants failed to show that the challenged rules have an effect on promoting integration of student athletes and their academic communities, while defendants have shown that limiting student-athlete compensation has some effect in preserving consumer demand for Division I basketball and football as compared with no limit. Plaintiffs have shown that not all of the challenge rules are necessary to achieve this effect, and that a less restrictive alternative set of rules would be virtually as effective as the set of challenged rules without requiring significant cost to implement. The less restrictive alternative would remove limitations on most education-related benefits provided on top of a grant-in-aid, while allowing the NCAA to limit cash or cash-equivalent awards or incentives for academic achievement or graduation to the same extent it limits athletic awards. Limits on compensation and benefits that are not related to education, and a limit on the grant-in-aid at not less than the cost of attendance would remain. The Sherman Act grants the power to district courts to prevent and restrain violations of Section 1 in accordance with the viable, less restrictive alternative discussed above. The NCAA may continue to limit the grant-in-aid at not less than the cost of attendance, and to limit compensation and benefits that are unrelated to education provided on top of a grant-in-aid. The NCAA may also limit academic or graduation awards or incentives provided in cash or or cash equivalent, as long as the limit imposed is not less than the athletics participation awards limit. Current NCAA limits on other education-related benefits that can be provided on top of a grant in aid are invalidated. The NCAA may not limit these benefits in the future. Each conference will continue to be able to limit any compensation or benefits, included the education-related benefits, that the NCAA will not be permitted to cap, as long as it does so independently from other conferences. So because the NCAA regulates all of the conferences, that effectively worked into or operated into or became a price-fixing scheme. And so that's what's illegal about that. The individual conferences or colleges probably can still do that because that's competitive, whereas the NCAA setting it is not competitive. Schools will remain free to set their own limits as well. Just said that. The NCAA will retain the right to define, in an exercise of discretion and good faith, education-related benefits and to regulate how schools provide them to student athletes. The NCAA may also assist conferences and schools in enforcing any conference rules limiting education benefits. The court will issue an injunction which will take effect in 90 days, but will be stayed pending the issuance of a mandate if a notice of appeal is timely filed. So this doesn't go into effect if they decide to appeal. The court will retain jurisdiction over the enforcement and amendment of the injunction. Conclusion. There is a great disparity between the extraordinary revenue that defendants garner from Division I basketball and FBS football and the modest benefits that class members receive in exchange for their participation in these sports relative to the value of their athletic services and the contributions they make. Class members contribute their elite talent and time, they limit their educational options, and they risk their long-term health to create enormous financial value for defendants. Restricting non-cash education-related benefits and academic awards that can be provided on top of a grant in aid has not been proven to be necessary to preserving consumer demand for Division I basketball and FBS football as a product distinct from professional sports. Allowing each conference and its member schools to provide additional education-related benefits without NCAA caps and prohibitions, as well as academic awards, will help ameliorate their anti-competitive effects and may provide some of the compensation student athletes would have received absent defendants' agreement to restrain trade. The clerk shall enter judgment in favor of the plaintiff class. Plaintiffs shall recover their costs from defendants. The parties shall not file any post-trial motions based on arguments that have already been made. It is so ordered. Judge Claudia Wilkin, United States District Judge. Very interesting there. I might be on the wrong side of this, but I often think that the students should be paid something in cash, but maybe there's good reasoning for that. The judge seems to think so. I'm not going through the 100 pages that I would need to figure out what that is yet, at least not on this stream. If we do that offline, if there's great demand for it, someone can ask. If someone really, really wants, we do offer a service where you can pay us to make your video. Of course, we have such a wonderful track record. We are currently 9 months behind on making one of those videos. So buyer beware.
I think just for those that aren't American or that aren't really aware of just how lucrative this is, the coaches for these teams are paid millions of dollars a year, but the athletes that are actually, risking their health, that are essentially like they're trying to get noticed by professional teams, but it is a very grueling process. It comes with a great cost, and they aren't like they're very limited in terms of what cash rewards they can get. So they have this job that is earning the university millions of dollars, and they don't get compensated based off of how valuable the service they are providing is.
And it smacks of unfairness if you are a person who thinks there should be fairness in the world. But yet there's this 100-page explanation, again, that we did not cover, that seems to confirm that there is some good reason not to pay them a large cash award for that. It might actually unbalance the education college athlete system. Personally, I think I might have an unpopular opinion here. I don't understand why athletics is tied to education. They don't seem to be related to me. They seem to be services that one organization can provide, but they don't seem to be related to each other. I get that historically, athletics is a good idea, and colleges host athletics because they make money for the college, and then the college can focus on education. That sounds like you're doing a for-profit thing to pay for a non-profit thing. And that's why I think athletes should be paid, and the system should recognize as a for-profit thing, that you're just funneling money into a non-profit thing. It doesn't necessarily seem illegal to me, it just seems immoral or unethical. But there's, like I said, 100 pages of explanation that I did not read, so I should not be an arrogant American and not form conclusions against the thing we just skipped when I just skipped it. Colleges, so many colleges are non-profits because they're state colleges. That's one. So that's a non-profit organization because it really can't be a for-profit organization and be a state college. It could be a privatized organization. The profits still have to go someplace, and the profits don't go to shareholders when it's a state actor. I'd have to think it through. Thank you very much to our Patreon supporters and our Twitch subscribers. Supposedly, Brandon has discovered a way to extract the Twitch subscriber list, so we will be incorporating the Twitch subscribers into the crawl and the patron panel and the reward list and all that. For now, please remember that this is a community-supported channel. This was only possible. We can only pay Brandon and only offset the cost of the channel and make it possible to make 4 or 5 videos for you a week by your donations and support, both monetarily and other ways, but primarily monetarily. You know, it's awkward to ask for money, but that's really what support means, is that we're asking you to give us money through patreon.com/LJFrench. For the month of March 2019, thank you very much to our $50 plus supporters: Jonathon Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Aspernari. And thank you very much to the $5 plus supporters who are scrolling on the LED panel behind me and will be on the crawl. And like I said, we'll add the Twitch supporters when we can. I'll leave some room here for dog video. This week, we look forward to releasing the videos that we went over this morning. I'll release a Supreme Courtship video. We'll go over the soccer players that sued for gender discrimination, the NCAA players who can now receive unlimited education benefits but still have a cap on their non-education or cash pay, the fake subpoena story, the My Cousin Vinny opinion, and then the Fomance opinion. All sound like great stories to release this week, so I look forward to all of that. Love you all. I am Leonard French, your favorite copyright attorney. Thank you all for being lawful, masses, and I will see you this week.